start this morning with, we'll go through our docket, but we'll be doing the, any of the short hearings, not the jury reviews. In other words, those that are ready for trial, we're going to wait until after we get through with the other things this morning. We'll do them this morning, but we're going to do the short hearings, you know, the pleas and that kind of stuff. We've got a lot of those that we soft-heartedly put on today's docket. So, Mr. Brooks, come on forward.
Morning,
And that's
Ken
Donald.
for Shane Donaldson, as he approaches. May I approach?
She's mine.
Thank you.
Now, this will be a plea to sex offender probation. Should have.
Would you go ahead and announce the full agreement? And are you okay with the score sheet, Mr. Brooks?
Yes, I am.
Your Honor, I think that probation needs the name of the defendant.
This is
Shane
Donaldson. This is
Donaldson.
Shane Donaldson, case number 23 CF 865.
Thank you, Your Honor.
Sure. Mr. Brooks, would you announce the terms of the plea agreement?
Yes, Your
I'll
Honor.
follow along here.
The terms of the plea agreement, it's going to be an adjudication of guilt, 5 years DOC suspended, conditioned upon 10 years probation, all standard conditions and terms, sex offender designation, and comply with all statutory requirements, 9430435. GPS, we request the $1 a day if the court approves that. No internet or social media access. Maintain gainful employment and costs.
Okay.
And Your Honor,
I don't understand I don't understand. When you say 5 years DOC suspended, conditioned upon 10 years of probation, I'm not tracking.
Your Honor. No, it doesn't need to be.
Conditioned upon successful completion,
Actually,
Your Honor,
it is okay.
of probation.
Your Honor, the suspension, we're asking the court to order 5 years of DOC, but to suspend it, and the condition is that he successfully completes the 10 years of probation. If he violates it at any time during those 10 years of probation, the 5 years will be imposed.
That's our understanding, Judge.
Okay. Very good.
And Your Honor, that's based on the totality of the circumstances. The state believes that it's inappropriate to recommend, to agree to a suspension in this case as opposed to the DOC sentence. We do understand that it is a downward departure. Actually, is it? And Your Honor, we are also
And
announcing a
the
no.
basis for the downward departure is what?
Negotiated plea agreement, Your Honor.
Uncoerced.
Correct, Your Honor. And Your Honor, also the state was announcing a null pros on count 1 as
Okay.
filed. I don't know if that was specifically announced. And the basis of that, it would have been double jeopardy.
Okay.
That's correct, Your Honor.
So you need to put that in here, and I think also you need to make clear that, and I'm assuming that each of the 2 counts remaining 2 and 3 are both the same 5 years suspended sentence conditioned upon 10 years, successful 10 years probation.
Actually,
correct?
the 10 years probation, Your Honor, would have to be only on count 1. I mean, I'm sorry, on count 2 as charged, because that
that's
is a
15
second-degree
years.
felony. And then count 3 and 4 are both the 5 years, so there would be 5 years probation, each one consecutive. So if we need to rewrite that, I guess we can.
Well, we do need to. And I also need to ask whether the suspended sentence operates as a cap when you have 10 years of probation. I'm trying to
Your Honor, it
make
would be,
sure we all understand that so that the defendant, so this discussion here today, Mr. Donaldson, is, listen close because it's for your benefit. So what we're trying, we want to make sure when I ask you questions in a plea, there's two things I have to determine. It's the only two things I determine. One, whether you understand the terms of the plea agreement, that's what I'm trying to do, clarify the terms. And then whether you're entering into this freely and voluntarily. So that's the nature of these questions. If any of these things prompt your questions, you know, pull Mr. Brooks aside and make sure you get all your questions. I'm going to be asking you in a second whether you understand all this, you had all your legal questions answered. Go ahead, Ms. Boss.
And, Your Honor, one other thing that probation reminded us of, it wasn't announced, but it does need to be sex offender probation specifically because it does fall into the Jessica Lunsford Act.
Okay. I agree. So, answer to my question?
The answer to your question is, Your Honor, it would be a cap as to the time in Department of Corrections based solely on a violation. Now, if the violation is a new law violation, then it does not limit any imposed sentence as to the new law violation.
The new law, sure,
Right.
absolutely.
So, but it's only as to, yes, so that it would be a cap as to this case standing alone. And it is above, actually, the guidelines. The guidelines are only 27 months in this case.
Okay.
So the 5-year DOC does give him an incentive to succeed.
Okay. You want to take your time and pull that aside and come back up when you get those corrections made, Mr.
Yes,
Brooks?
Your Honor.
Why don't you
We'll do that.
'cause we've got
Thank
some
you.
other cases.
If I can point out that he will also have to comply with the 1,000-foot rule regarding his residence, so that, I don't hope that won't be a problem when we get to the probation office.
Those would fall under the category of standard sex offender probation, correct?
Correct.
So we don't have to put it specifically handwritten in there, but that's very important that he understands that, and I'm sure you'll be going over, when there's sex offender probation there, you go through, there's a lot more kind of where you explain to him the standard requirements. Okay. Is Ms. Farkas here? Mr. Noakes? Okay. Come on.
I saw her. Walking in behind you. She was. And then she,
May I approach?
You may.
but you don't have the CD that will move. I have nothing. I'll see if I can buy her.
I'll put it on here. I'll just get your piece of paper. I'll just get your piece of paper.
Good morning. Would you announce the case and state the terms of the plea agreement, Mr. Noakes?
I will, Your Honor. The defendant's name is Stacy Crowley. The case number is 22 CF 656. Judge, the state and I have reached an agreement that she's going to enter a plea as charged, that she'd be adjudicated guilty and sentenced to credit for time served. $6.15 in court costs would be assessed and $150 court-appointed legal assistance fee. Ms. Crowley, I think the judge will try to talk with you now.
So adjudicated guilty on both counts?
Yes, sir.
Okay. Ms. Crowley, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Ms. Crowley, I just want to make sure you read the plea agreement,
Yes, I did.
and I see you've signed it, you've gone over it with your
Yes, sir.
attorney?
Yes,
Made
sir.
sure you had all your legal questions
Yes, sir.
answered? Understand this is the final resolution of
Yes,
all
sir.
your cases?
Yes, sir.
You understand that? Okay. Based upon that, the court will accept the plea agreement. The defendant will be adjudicated guilty on both counts and sentenced to credit for time served, along with the court costs and fees. Once you put on here, she's got 180 days to pay them. So you got 180 days to pay from now,
Yes, sir.
and
Okay.
after that, it'll go to collections.
Thank you.
Sure.
Your Honor, just for the court's knowledge, this is not a downward departure. Her total sentence points are 25.6.
Okay.
So this is not a downward departure. I don't know if Mr. Noakes has the score sheet.
Do you have the score
Do you
sheet?
have the score sheet, or do I need to submit it? Your Honor, I'll submit the score sheet at a
Okay.
later time, after I get Mr. Noakes.
Very good.
I'm making to get it to you in just a minute. I'm gonna get her out and get her taken care of, Judge.
Very good. Very good.
I gotta get you.
I think Mr., do you know where Miss Farkas is?
I do not, Your Honor.
Is she in the building?
I saw her walk up to the courthouse, but I didn't see her come into the courthouse, Your Honor. I'm trying to
Anybody
look
runs
at-
into her, tell her to come on in. We need to deal with something. So, Mr. Durrell, I think you're up. Mr. Medina, was there something?
Oh, no, I just wanted to, I didn't know if, what was on the agenda. I have two ready for pleas or out of custody.
We're doing
whenever-
the pleas first.
Yes, sir.
And then we'll do the trials after this
Yes,
morning.
Your Honor.
Mr.
Thank you.
Durrell?
And we do have a written plea, if I may approach it.
You may. Thank you. Would you please announce the case and the agreement, Mr. Durrell?
Hopefully that'll work.
May it please the court, Dustin Durrell on behalf of Mr. Frank Dixon. This is 22 CF 1061. Your Honor, at this time, Mr. Dixon will withdraw his previously entered plea of not guilty, enter a plea of no contest to count 3. Pursuant to agreement with the state, counts 1 and 2 will be dismissed. Sentence to be imposed on count 3 is 11 months, 29 days of administrative probation. Do not possess firearms during probation. And I believe that was it, Your Honor.
Your Honor, that is it. Mr. Dixon's.
Yeah, administrative probation. That's the.
Were the parties in that approached?
Yes, Your Honor.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury.
Okay, Mr. Dixon, would you please raise your right hand, sir?
Yes, sir.
You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you just heard your attorney state the terms of your plea agreement.
Yes, sir.
And I see those same terms are contained in the written plea agreement that you've signed. So I just want to make sure, one, did you read this closely, the plea agreement?
Yes, sir.
And did you go over it in detail with your attorney? Make sure you had all your legal questions answered.
Yes, sir.
Okay, and you understand that by entering this plea agreement here today, you're waiving the right to go to a trial. This will be a final adjudication of your cases,
Yes, sir.
of your charges. 2 of the charges will be dismissed by the state, correct?
That's correct, Your Honor.
Okay. And the state is in agreement as announced?
Yes, Your Honor, this was
Okay.
the state's agreement.
So 2 of those will go away, but the final one, there will be
And I believe it's a withhold of
a
adjudication.
withhold of
Your Honor.
adjudication. That's why I was checking that.
Thank you.
There will be a withhold of adjudication as well. Okay? So is that your understanding?
Yes, sir.
Any further questions of your attorney?
No, sir.
Okay, based upon that, the court will accept your plea agreement here today. Counts 1 and 2 will be null pros by the state. There'll be administrative probation, and it'll be 11 months, 29 of this administrative probation, standard court costs, and you're not allowed to possess a firearm during this probationary period. Any questions?
No, sir.
Okay.
Your
Thank
Your
you.
Honor,
Thank you, Your Honor.
Your Honor, probation was wanting me to make clear that because it's 11 months, 29 days of probation on misdemeanor, that it is administrative non-reporting probation, but it's JCS.
Okay.
Yes, thank you.
Do we have, do you have a card for JCS? We got it?
You'll, I've got a copy of the QR code.
Very good. Okay. Thank you very much.
Thank you very much, Your Honor.
Thank you, Your Honor.
Mr. Gilbert?
May I approach?
You may. Thank you.
Your Honor, we're here with Joseph Carroll in 23 CF 1357. He was originally charged with child neglect without bodily harm and a DUI above .15. The agreement with the state is on count 1. Adjudication would be withheld. It'd be 6 months community control, followed by 2 years probation with a curfew of 9 p.m. to 6 a.m. Court costs of $666. On count 2, adjudicated guilty, $1,000 fine. 1129 probation concurrent with count 1, 6 months license suspension, 6 months interlock, 30-day vehicle impoundment, DUI school, victim impact panel, 100 hours community service, SAET, or substance abuse evaluation, any treatment, cost of $438.
State,
That's the state's agreement, Your Honor.
do we have a score sheet?
Your Honor, this is not a downward departure. I will, if Mr. Gilbert doesn't have it, I will get it to the court.
Okay. Mr. Carroll, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You heard your attorney state the terms of your plea agreement.
Yes.
And I see that those same terms are contained in the written plea agreement that you've signed. So my first question is, have you read the plea agreement closely?
Yes, Your Honor.
You understand that by entering this plea agreement, you're waiving the rights to go to a trial and to contest these charges, et cetera. This will be a final adjudication of this case.
Yes, Your Honor.
And have you had all your legal questions answered regarding, in other words, what the ramifications are of this plea agreement
Yes, sir.
on your record, et cetera? Do you understand all
Yes,
that?
sir.
You believe this is in your best interest to enter into this?
I do, Your Honor.
Based upon that testimony, the court will accept your plea agreement. As to count 1, the child neglect, there'll be an adjudication, it will be withheld, and the defendant will be sentenced to 6 months community control, followed by 2 years of regular probation with curfew, a special condition. The curfew will be from 9 to 6 a.m., 9 p.m. to 6 p.m. Standard court costs. Count 2 will be an adjudication of guilt, $1,000 fine, 1129 probation. That'll be concurrent with count 1, so it'll be done at the same time. There'll be 6 months license suspension, 6 months interlock, 30-day vehicle impoundment, DUI school, community service hours, and substance abuse evaluation and treatment if called for. Okay, any questions? Thank you very much.
Your Honor, there were, right, so I have 3 of TR 72.
Hold on, say, are you listening?
Yes, sir, sorry.
Okay.
So, Your Honor,
There's 2
there are-
TR cases, just want to make sure you're,
Yes, Your Honor, the state was going to agree to merge and dismiss these TR cases.
okay, and would you announce those 2 case numbers?
Right, so I have 3, TR 7272, failure to stop, TR 7322, improper signal, and TR 7323, speeding.
And we're going to merge and dismiss those, is that what the state said?
Yes, Your Honor.
Does that need to be in the plea agreement?
I
don't think so, Your Honor, as
Okay.
long as it's announced on the record and if it's in the
Okay.
clerk's minute.
Very good. Just wanted to make sure, okay. Probation, question?
Your Honor, may we have the entire length of probation to complete all the DUI conditions?
Yes, ma'am. Okay, thank you, Mr. Gilbert.
Thank you, Your Honor.
Ms. Farkas and Ms. Davis,
Thank you, Judge.
we need to approach.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with BriarPatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at dave'stirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Judge, if I can be excused for
You
now.
may.
Well,
Thank you.
he is lawyer. Well,
You
I
may.
think
Thank
he
you.
specifically because.
Mr. Brooks, are we ready?
reason-
We'll be in just a second.
Okay. Who's ready to go? Counsel, come forward.
Yes, sir. Jason Cobb on behalf of Barry Shasta.
Oh, goodness. You see, that's when we need that one. I don't understand. Well, I think, Your Honor, could we approach before that starts?
Come, you may approach.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Bring him back later this morning.
Yes, sir. Mr. Gaspin, this way. They're gonna bring you back down.
So, Mr. Powell was here, wasn't he? Mr. Powell, are you ready? Okay, come on. Are you handling both of them?
I am, Judge. I will be one moment.
Oh, wait a minute, I
Speaking
did.
with Mr. Hooper.
Sorry, I didn't go back.
Is Mr.
I forgot something.
Is Mr. Hooper, I had ready for trial. Are we going, proceeding to trial?
I've got to talk to him.
Okay, so let's just do Mr. Cole, and then we'll.
Pass me for a minute.
Yes.
Thank you, Judge.
Would you announce?
Bo Powell for the record on behalf of Thomas Cole, case number 23 CF 851. We have a negotiated plea agreement. And Mr. Cole would be entering a plea to count 2, which is traveling to meet a minor. Counts 1 and counts 3 would be dismissed by the state.
Do you have an extra copy so I can be tracking it while you're?
Yes. If I can approach you.
Yes. Thank you. And is the defense okay with the score sheet?
No objection to the score sheet.
Would you please announce the agreement?
Judge, it would be adjudication of guilt. It would be 10 years of probation with a suspended prison sentence of 10 years. There'd be no unsupervised contact with minors other than his biological children. There'd be a GPS monitor at $1 a day. And we just ask, it's not in the agreement, but we'd ask the court to just, he does work and travel for employment purposes, typically in Alabama. So we got to just, we're very concerned about having issues for employment purposes. So that's just something we need to put on the record. There'd be fines and court cost and a designation.
And what impact do you think putting it on the record would do?
Well, I just wanted to bring it to the court's attention that
And what can I do about it?
Well,
I mean, there are certain rules that are in probation.
Right.
Tracks those, and probation standing back there ready to give input. I can see.
Right.
And Your Honor, it does need to be sex offender probation.
Right.
Correct. Yeah. I just wanted to bring it to your attention that
If it makes you feel better, but we're not taking any action
Right.
on it. I just want to
I
make sure
understand.
that you don't think that by you putting it on the record, it has some impact on this plea agreement, because it doesn't.
No, I know that. We're
Okay.
just making you aware of it and the state aware and probation aware that that is something we got to talk to probation about.
Okay.
And I did speak to the state about that, and the main thing is informing probation of his employment and travel schedule.
Okay.
May may I inquire as to what kind of travel schedule we're talking about? If you have,
Sure. What kind of anticipated travel do you have with your work?
I do construction with my boss. He owns property up there that we're up there doing construction on,
Up where?
up in, I think it's called Inverness, Alabama.
Okay.
so if I may, we will not allow any overnight stays, and if you're on the GPS monitor, we have to be able to supervise you, and any alarms, you have to immediately come to the probation office to be addressed. So I'm not, this is, might present a big problem. If you're out of pocket and you can't handle any GPS alarms, you have to be back, you have to live here, and every night you have to be home.
You understand that?
Okay. Where's Inverness, Alabama?
Outside of Birmingham.
That's not gonna work. I'm sorry, Your Honor.
That's
Too
south
far
of
away to
Birmingham.
be on GPS and be away.
It's a 3-hour drive.
It's not gonna work.
That's a
Okay.
3-hour
I appreciate you letting him know. Sure, no, it's okay. You're
You
just
okay
being,
with-
you're just
understand that?
being honest with it.
Got it. Yeah.
So based upon what probation is saying, because they're in charge of that, we're not. Once you're placed on probation, if we do that here today, then they administer it. I'm no longer am involved. You won't ever talk to me unless you violate, and then you don't want to talk to me. But that's the only reason you would.
Understood.
Okay, you still want to go forward even though there may be some issues with your work and being able to fulfill this
Yeah, that's fine.
probation?
Mhm.
Okay.
I'll just work here.
Okay, you understand that?
So he understands we will not be able to accommodate that. You cannot have him in Birmingham, Alabama.
Ma'am, you said it very clear, and
He understands.
Thank you.
Yeah.
We just wanted to bring it to your attention, that's
I
what.
appreciate that.
Sure, sure. It's important that you be clear about things now. I mean, the whole purpose of this dialogue is two things. One, to make sure you understand exactly what you're pleading to. Nobody's trying to trick you. We don't want to send you down the road, oh, hey, gotcha. You know, that's not what this is about. Actually, it's just the opposite. We want to bend over backwards and make very clear, this is not an easy thing. You know, you think, well, yeah, I got this resolved. Well, it's not like that. It's really the beginning of a process that looking down, a very hefty suspended sentence. So it's just the beginning. And we want to make sure you're clear about what you have to do so that you don't do that. Got plenty of people in jail, prison. They're full up, We're not looking stick a few more people in unless you violate.
Correct.
Then we'll follow the law and do that, okay?
I totally understand.
Okay, very good. So, did you finish your rendition before we?
I did,
jumped in
Judge,
there?
just
Okay.
wanted to make sure
Sure.
that issue, and then Mr. Cole does have biological children, and we just wanted to make sure there was, one of the conditions is no unsupervised contact with minors. We just want to make sure that doesn't include his biological children.
According to this, it does. The way I read it, I don't see any exceptions.
Did you not write that in?
State?
Your Honor,
But-
we had no objection to that. That was one of the terms we agreed to. If you didn't write it in there, you need
No.
to make sure you did.
In other words, that he can have unsupervised with his own children.
That is correct, Your Honor. We don't have concerns for that.
You just need to put it in here, Mr. Powell.
Just let me pass it for a moment.
Okay, that's fine. That's fine. Okay. Mr. Brooks, you ready?
We are, Your Honor.
Let's do
Okay,
that.
come on.
Your Honor, I'm going to, again, this is Shane Donaldson's case, 23 CF 865. I'm going to read this into the record, then I'll give it to you.
Okay, thank you very much.
The sentence recommendation
Ms.
is...
Bossell, listen to that closely so that you can object if he's not saying it right. Go ahead, I'm sorry. Go ahead.
On count 2, 5 years DOC, suspended, conditioned upon 10 years sex offender probation. Count 3, 5 years DOC, suspended, concurrent with counts 2 and 4, conditioned upon 5 years sex offender probation. Count 4, 5 years DOC, suspended, concurrent with counts 2 and 3, conditioned upon 5 years sex offender probation, to be consecutive to count 3, 10 years sex offender probation total. GPS requirement, $1 a day with court approval, no internet or social media access, maintain gainful employment, costs, and then, of course, the 1,000-foot rule, which was brought up by probation as part of sex offender probation, Judge. And that is the agreement. May I approach?
You may.
That is the state's agreement, Your Honor.
Thank you. Thank you, Mr. Brooks. Okay. Mr. Donaldson, you're still under oath. I think I swore you in before, didn't I?
No.
Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, as you may have overheard me say to some of the other people that are doing the pleas, purpose of my questions here, this colloquy, is to determine, make sure you understand what you're agreeing to, make sure it's free and voluntary.
Yes, sir.
So, fortunately, we got some clarification, and that's good. That's what we want. We want to make sure you're clear, because there are very serious consequences in this if you violate. And we don't want you to violate, but if we do, we want to make sure you understand what's going on. Okay? So you heard your attorney state the terms of your plea agreement.
Yes, sir.
And those terms are contained in the written plea agreement. It's called a sentencing recommendation, but it's really a plea agreement.
Yes, sir.
And I see you've signed it. Have you read this plea agreement closely?
Yes,
and gone over it with your attorney? Make sure you had understood all the legal issues involved in this?
Yes, sir.
Because there are a lot, importantly, you're waiving some valuable legal rights.
Yes, sir.
By entering into this plea agreement. The right to go to a trial, the right to force the state to prove their case beyond every reasonable doubt, confront witnesses, all. You understand all that? You're waiving those rights. Final adjudication here today.
Yes, sir.
Okay. And you do believe that this is in your best interest?
Yes, sir.
And there is a factual basis for the entry of this plea here today?
Yes.
Yes, Your Honor.
Okay. Very good. Do you have any further questions of your attorney regarding this plea agreement?
No, sir.
Okay. Very good. Based upon your testimony here today, the court will accept your plea agreement, and count 1 is going to be dismissed by the state, correct?
That's correct, Your Honor.
I don't see where it says count 1 is dismissed in the plea agreement. Maybe I missed it. Count 1 is dismissed, but it's not in the agreement.
Write it on
You
there.
need to just write
Ken,
it.
you can just write it on there, Mr. Brooks.
Just write it on here.
Yeah.
Everybody's in agreement on it, but.
Yes, sir, and the basis
but-
was double jeopardy on that, Your
Yeah,
Honor.
yeah. Thank you. Okay. So we all knew it, we all agreed to that, but we didn't state it. So count 1 will be dismissed. Count 2, defendant is sentenced to 5 years, a DOC, which is suspended, conditioned upon successful completion of 10 years of sex offender probation. Count 3 is 5 years, sentence of 5 years DOC suspended, concurrent with count 2, and conditioned upon 5 years, a successful 5 years of sex offender probation. Count 4, sentenced to 5 years DOC suspended, concurrent with counts 2 and 3, conditioned upon 5 years sex offender probation to be consecutive to count 3. So there's a total of 10 years sex offender probation.
Yes, sir.
Okay? So 5 years suspended, 10 years sex offender probation. And there's a lot of terms and conditions that are unique to that. One of those, you can't be within 1,000 feet of school. They'll go over that with you, but I assume you've gone over that already and understand that there are some additional restrictions. You will be required to wear a GPS. We'll make sure it's at the lowest possible rate of $1 a day. Of course, no internet or social media. Contact, maintain gainful employment, cost, 1,000 feet rule. Do we need to put in here, I'm assuming no unsupervised contact with minors?
That actually is a condition, I believe, of sex offender probation.
Okay, just wanted to make sure we don't need to add it in
And
there
that's our
separately.
understanding.
Okay, very good. Any questions, sir?
No, sir.
Okay, thank you very much.
Thank you.
Thank you, Your Honor.
You
That's
do
all
have
we have
30
to
days, you do have 30 days to appeal this, even though you entered into an agreement, you do have 30 days to appeal the formal sentence.
Thank you.
Thank you.
Thank you. That's all I have for you.
Thank you, Mr. Brooks. Mr. Medina? you
Yes,
want-
Your Honor, I have a couple of out of custodies that are ready to go. Alphabetically, could I call
Sure.
Shakia Brown? Ms. Brown is approaching. Her case is, it's Shakia Brown, 23 CF 259. And we have a plea agreement in her case, Your Honor. There is going to be an amended score sheet because 2 of the 3 charges are being dismissed, and the first count is being reduced to a lesser included. I'm just going to point to that change for her, Your Honor. May I approach, Your Honor?
You may. Thank you.
Sorry, Judge, may I hand probation a copy too?
Sure.
Your Honor, under the terms of the agreement in 23 CF 259, Shakia Brown will be pleading no contest. That will be explained in a moment, but that's only as to a lesser included on count 1. The state is agreeing to dismiss counts 2 and 3 in exchange for a withhold of adjudication to a lesser included offense, sale, manufacture, or deliver, or possess with intent to sell, manufacture, or deliver. That's a second-degree felony. That will be on count 1. 2 years probation, substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days, random urinalysis, 615 court costs, 150 public defender fees, testify truthfully if called regarding co-defendant, waive costs of supervision, and that is the agreement, Your Honor. Again, it's a withhold. She has no priors, so she won't become a convicted felon, and she understands the importance of complying with probation. If there are any questions.
What's the maximum sentence on the lesser included?
The lesser included, it's the same maxes as the current count 2 that's being dismissed. It's 15-year max prison, 10,000 max fine.
Very good.
That's correct, Your
Ms. Brown, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, did you hear your attorney state the terms of your plea agreement?
Yes, sir.
I see you've signed the written plea agreement that contains those terms. Have you gone over it?
Yes.
Have you read it closely, gone over it with your attorney in detail?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving the right to go to a trial.
Yes, sir.
This will be a final adjudication of your case. You're waiving some other rights. Do you understand? Have you gone over all that with your attorney?
Yes, sir.
You believe this is in your best interest to enter into this plea agreement?
Yes, sir.
You're entering into it freely and voluntarily? Have you had all your legal questions answered of your attorney?
Yes, sir.
And just importantly, you understand what the maximum, did you hear your attorney state the maximum sentence on the lesser included offense that you're pleading to here today?
Yes, sir.
What is it? What's the maximum?
If you were to violate your probation, what could you go to prison for up to?
What's
how
the
many
maximum?
years?
Oh, 5 years?
No. It's the same as count two.
Oh, yeah, 15.
15. Right. I want you to hear that. Okay. This is probation. This isn't the end. This is the beginning. I'm gonna sound, what I'm about ready to say, I'm gonna sound like cute a little bit. I'm not trying to be cute, but I'm being honest. Your new best friend needs to be your probation officer, because you're gonna have to abide by this. A lot of people walk out of there happy and don't go to jail and go out on probation. You got a back end of this that's heavy. And if you violate, they're gonna come back asking for a serious DOC sentence. Okay? So that means you're gonna have to wake up every morning, figure out what you gotta do that day, and that needs to be your top priority. Do you understand that?
Yes, sir.
I want you to be successful. And the reason why I'm saying it's not to try and scare you or threaten you. I want you to be successful, but you're gonna have to take this serious in order to do this. Okay? Because these are serious charges. You with me?
Mm-hmm.
Are you willing to do that? Are you comfortable
sir.
doing that? You believe this is in your best interest to enter into this plea agreement? Very good. Based upon, and the states, and this is the states in
Yes, this is the
agreement?
state's agreement, Your Honor.
In the dismissal of counts 2 and 3?
Yes, Your Honor.
Very good. The state agrees to dismiss counts 2 and 3, and the defendant, on to count 1, will be sentenced to a withhold of adjudication to the lesser included offense of sale, manufacture, delivery, or possession with intent to sell, manufacture, or deliver on count 1. And he'll be sentenced to 2 years probation. Substance abuse evaluation has to be done within 30 days with any recommended treatment to commence in 60 days, random UAs, court costs, and agree to testify truthfully if called upon regarding your co-defendant. Court will waive the cost of probation supervision.
Your Honor, I appreciate that, because she's a single mother with 3 children, works hard, so thank you.
That's another reason why you need to pay attention to this, right? Okay. Any questions concerning any of this? Okay. Good luck. I do have to tell you that you do have a right to appeal this in the next 30 days, okay?
Thank you, Your Honor. Next would be Justin Michael Emery. Your Honor, I'm approaching with a signed plea and sentence agreement on these charges, misdemeanors, so there is no score sheet. May I approach?
You may. Thank you. Would you please announce the plea?
And it's going to be supervised by JCS. Could he have a card to show where to get to JCS? Thank you. Extra copy for you. Thank you. Your Honor, under the terms of the agreement in 23 CF 1150, Justin Michael Emery will be pleading nolo contendere as follows. Adjudication of guilt to lesser included offense, simple assault, that's a second-degree misdemeanor, with a 60-day jail max and a 6 months probation max. That's on counts 1 and 2 as charged. Excuse me, that's on counts 1 and 2 would be the lesser included offense, simple assault. And he's also going to be adjudicated guilty as charged on 3 and 4, which are first-degree misdemeanors. There'll be 6 months probation on count 1, followed by 6 months probation on count 2, followed by 11 months, 29 days probation on count 3, followed by 11 months, 29 days probation on count 4. So it totals up to a couple of days shy of 3 years, right? Substance abuse evaluation within 30 days, and they recommend treatment to commence within 60 days. Cooperate with DCF, FFN. No violent contact with Sarah Ellis. The minors, SD or NL. 967 court costs, 150 offender fees, and again, supervision will be by JCS.
And Your Honor, that is the state's agreement. I have confirmed that there is no open case with FFN. The issues have been resolved. So that was just in case there becomes another case.
So that provision in this plea agreement has been, has already been accomplished?
Yes, Your Honor.
Okay, that's good. Say that for the record. One question I have is simple assault a lesser included of child abuse? The way it's worded, you're saying it's a lesser included. I just want to make sure we're kind of technically correct.
If it's not, Your Honor, that was the intended charge for that the state would plead to him. The state, if it needs to, will file an amended information.
Your Honor, my position would be that it is. I'm not sure what it is at the tables at the back on the jury instructions, but basically the allegation on count 2, which was child abuse, was the same allegation that was related to count 1, basically. Basically, there was a
well, I'm just asking a technical question because the way it's worded, it says the lesser included. I just don't want.
Your Honor, because a simple assault could be threatening of mental and physical.
Okay.
I believe it is.
If you all agree,
We don't have to.
lesser included didn't jump out at me as being lesser included, but I'm not saying that it isn't.
Thank you, Your Honor.
Just raised a question.
Yes, Your Honor.
Okay, Mr. Emery, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you've signed.
Yes, sir.
So have you read this closely?
Yes, sir.
Gone over it with your attorney in detail, make sure you understand the terms of the plea agreement?
Yes, sir.
You understand you're waiving the right to go to a trial. You've heard me say it several times here today.
Yes, sir.
You believe this is in your best interest to do this plea agreement?
Definitely, yes, sir.
And you understand this will be a final resolution of this case?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea agreement. And there'll be an adjudication of guilt to the lesser included offense of simple assault as to counts 1 and 2. And you'll be, and there'll be an adjudication of guilt as charged in counts 3 and 4. The defendant will be sentenced to 6 months probation on count 1, followed by 6 months probation on count 2. So those are consecutive, not concurrent. Followed by 11 months, 29 days probation on count 3. Followed by 11 months, 29 probation on count 4. That's just short of 3 years, right? Is that what we're trying to say? Is my math correct? Is that what you said, Mr. Medina?
Yes, Your Honor.
Just short of 3 years. Okay. In addition, there'll be substance abuse evaluation within 30 days with any recommended treatment to commence within 60. They have a statement here, cooperate with DCF, FFN, but apparently that's been completed. no violent contact with Sarah Ellis, and then 2 minors, SD or NL, and then some standard court costs. This will be supervised by JCS. And what's the last statement? Consecutive with existing probation on 23 MM 2001? Is that correct? Did I read this? It's an abbreviation. I can't read.
May I?
That's
may I
all right.
see what- I apologize. I may not have written everything.
Just that last sentence
Yes,
regarding the
Judge.
misdemeanor.
Just make sure.
Sure.
Your Honor, he has a few months left. 23 MM 2001 was something he's already serving, so this will be concurrent with that. It'll be supervised by the same entity, JCS. So
Okay, so it's concurrent with that.
Concurrent with existing probation at 23 MM.
Okay, so they're not stacking it on top? Right. Okay, very good. Any questions regarding this?
No, sir.
Well, you do have 30 days to appeal this. Good luck. Any other,
Those are my out of custody pleas, Your Honor.
okay.
I have some inmates to talk to.
Mr. Cotton,
Good morning, Your Honor.
are you?
Your Honor, I've got Mr. Abney on the docket. Judge, we scheduled this for a plea today, but after speaking with Mr. Abney and the state, we still have an agreement for a plea, but that plea has a drug offender probation requirement. That has a curfew. Mr. Abney's in the middle of getting some businesses open, and so I talked to that the curfew would interfere with. We're going to get that started, but we would like to move it to your March 14th so that you can wrap up some things and not run into a problem on that.
Okay, why don't we come back on March 19th?
19th? Is that okay?
A little
Yeah, that's
heavier.
fine, I'll be here.
March 19th in the morning, AM.
9 a.m.?
9 a.m.
See you then.
I'm sorry, did somebody? Yes?
That's fine, Your Honor,
Okay,
yes.
very good.
I'll be here.
Okay.
Thanks, Judge. Good to see you.
Thank Mr. Cotton.
Your Honor, can I call one in custody? It's a max,
Sure.
and that may help. Matthew Peters.
Peters?
Yes, Your Honor. Mr. Peters should be number 17 on the morning docket.
Okay, very good.
And Your Honor, maybe approach on that?
Sure.
Yes, Your Honor. And I talked with Mr. Peters. He and I have gone over the plea agreement. That'll give me time to get a bit more detail with him. My anticipation is on the 14th, we'll have a plea for the court.
Very good. Thank you very much.
And that concludes my business before maybe exceeds. Thank you, Your Honor.
Can I give him a copy of the plea?
Mr. Moats?
So the last case I've got this morning is Ian
What's
Thornton.
that week?
It's 23 CF 2447, which is a new case, and 21 CF 1471, which is a violation of probation.
Hold on a second. I don't have Thornton on my docket. I was on there before, and it was.
So we were here.
Continued, or?
We were here Monday, and we set it for this morning just to see if we could get something worked out. So I didn't know if it was on the docket or not, but it's on my book, and he's here.
You're not, I have him on, as number 9 on the docket I have.
On what?
I have him as number 9, docket entry 9.
Yeah, the new one that came out yesterday didn't have it, but we can still deal with it. I'm just, what are we doing with it?
Judge, we did not get a resolution
However,
Okay, so now, just for the record, make sure the clerk has this. What is the case number again, or case numbers?
23 CF 2447, which is a new law violation.
Right.
And 21 CF 1471, which is a violation of probation.
Right.
And so the state and I have been communicating, I was hoping I could get something worked up. We're not going to get it resolved, however, so we're going to need another date. And then the state, these are the new law violations of a newer case, although I'm the third attorney that he's been appointed. So it's been hanging around for a little bit.
The new isn't
Right.
technically new, but it's not.
Yeah, January 12th. So the state's got to send me discovery. He's asking me to ask the court, because his dad's in bad shape, he's in hospice, dying of cancer. He's asking me to ask the court for some type of furlough to where he can visit with his dad. He understands that, and I told him that I can't think of the last time a furlough was granted, basically.
You don't monitor anything at all, sir.
State, honestly, you're raising this. I haven't looked at the case, don't know the circumstances. I'm unprepared to really,
Yeah,
if the state is in agreement, if the state objects at this point, I would have to look at it by some.
Your Honor, as a matter of course, the state objects to furloughs. So yes, we would object to a furlough.
What's the quickest date we can have a hearing on that? I'll file a motion.
The quickest date is 3/14.
Okay. I'll file it in,
And it's in the morning.
9 a.m. Okay.
That's right.
Okay. Thank you, Judge.
Thank you.
I'll look at it. I'll make it a bond here.
Thank you. We can go ahead and set them to the next meeting. Mr. Powell, are you ready?
I'm ready, Judge.
I'll make it a bond.
Cole?
We can recall Thomas Cole.
Okay.
If that's something.
He's present. Bo Powell for the record, and Thomas Cole, 23 CF 851. Got a cleaned up plea agreement.
Okay.
If I could approach.
You may. Thank you. Okay. You want to go ahead and announce the terms of the plea agreement?
Mr. Cole would be entering a no contest plea to count 2, traveling to meet a minor. It would be an adjudication of guilt, 10 years of probation with a 10-year state prison sentence suspended. There'd be no unsupervised contact with minors except for his biological children. There'd be a GPS monitor at $1 per day. The state's not objecting to waiving the cost of supervision if the court's inclined to do so. There'd be a sex offender designation and then the minimum court cost.
State?
That is the state's agreement, Your Honor.
And then counts 1 and 3 would be dismissed.
Very good. Okay, Mr. Cole, would you raise your right hand? I think I swore you in already. I'm going to swear you in again. Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Do we have a score sheet?
I believe I left it up there.
And it's not a downward departure, is it?
It is.
It is.
By-
It is, Your Honor.
Based on plea agreement.
Very good. Okay. So, Mr. Cole, you heard your attorney state the terms of your plea agreement. I see you've signed a written plea and sentencing agreement that contains those same terms.
Your Honor, I'm sorry, it does need to be sex offender probation. I don't know if that was specifically announced. It's based on the
That's
charges.
correct. The sex offender probation.
Yeah. We need to go ahead and put that in there.
Just write that in there, if you
Yeah.
will.
Just inserts asterisk sex offender. Are there any, I mean, that carries with it a lot of requirements. Do we need to list any of those specifically that in addition to what, just just put a little asterisk and say.
No, Your Honor, I believe the main one, the fact that we're allowing unsupervised contact with his own biological children would be the main one that would need to be clarified. That's a
Right.
standard condition, and I believe that was addressed.
Okay. So, importantly, Mr. Cole, you understand that when we announced the 10 years state probation, it's sex offender probation. That carries with it a number of specific requirements. Like you can't be within 1,000 feet of a school. That's one. But they're going to go over it with you, but I want to make sure you're comfortable with it and you've kind of gone over the requirements and you're comfortable entering into those, because you got a heavy back end to this if you mess up. Right? Are you comfortable with these requirements that you can maintain those? Are you
Yes, sir.
comfortable entering into this plea agreement with those requirements?
Yes, sir.
Probation, do you have a input?
Yes, Your Honor, we've been looking at his specific statute for
Ye-
count 2.
Yes.
And we believe that will not carry the 1,000-foot rule.
Okay.
That will be determined precisely when he gets to the office. But based
Okay.
on what we're doing right now, we do not believe the 1,000-foot rule.
Okay, that may not apply. So they'll go over with you specifically based on the statute and based on precise. They're very good about walking you through, and I'm sure Mr. Powell's also done it in advance of that. But I just want to make sure you're clear about these requirements and you're comfortable entering into those.
Yes, sir.
Okay. Have you had all your questions answered by your attorney about this plea agreement and kind of what it all entails and how it affects you legally?
Yes, sir.
And you understand that you're waiving the right to go to a trial and force the state to prove their case. This will be a final resolution in this case. Do you understand that?
Yes, sir.
You believe it's in your best interest to do this,
Yes, sir.
to enter into this plea? And is there a factual basis for the entry of this plea?
We stipulate.
There is, Your Honor.
Okay. Very good. Based upon that, the court will, that testimony, the court will accept your plea agreement. The state is agreeing, and counts 1 and count 3 are both dismissed. Count 2, the court is sentencing to an adjudication of guilt on this charge of traveling to meet the minor and sentencing the defendant to 10 years state sex offender probation and 10 years state prison sentence suspended. In addition, as a condition, among other conditions, no unsupervised contact with minors other than your biological children. And the GPS monitor will be at $1 per day, and the court will waive the cost of supervision, and there'll be no internet access, and there will be sex offender designation and standard fines and court costs. Any question? Okay. Thank you. You have 30 days to appeal this sentence, even though you just entered it. Thank you.
Next matter will be Stephen Hooper.
What are we doing? Is that what we're doing? Oh, yeah, I'm okay with that. Did you do that? I did, yeah, thank you. Thanks for letting me. Okay.
There you go, Mr. Powell. I don't have to provide the court with this, but I can put on the record what it is.
If we get that. Let's see.
Powell.
Doug Powell for the record on behalf of Stephen Hooper, case number 22 CF 1747. Mr. Hooper's present. We have a negotiated plea agreement. If I could approach.
Thank you. Would you please announce the agreement?
Mr. Hooper would be entering a plea of no contest to count 3, traveling to meet a minor. Counts 1, 2, and 4 would be dismissed by the state. It'd be an adjudication of guilt, 3 years state prison with credit for all time served, followed by 7 years sex offender probation, no unsupervised contact with minors, no internet access, a sex offender designation, and then the minimum fine for costs.
That is the state's agreement, Your Honor. It is within the guidelines. I will put on the record, Your Honor, I apologize, I don't have the score sheet, but his score would be 56.2 points. So that would be the minimum, and then the maximum would be the 15 years.
I'm going around to talk.
I'll have to, works out, I believe it's 21
We have no
months.
objection to the score sheet at 56.2 points.
That's the points, that's not the months.
Correct.
I believe it's 21 months, Your Honor, would be the minimum guidelines. Let me do this real
21,
quick.
okay, very good.
Roll
So it's
that.
not a downward departure.
It is not, Your Honor. It would be a minimum of 21 months based on the 56.2 points. So it is not a downward departure.
Mr. Hooper, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, sir.
And in here it says, it just uses the term designation. I assume that's sex offender designation.
It is, Your Honor.
Do we need to put that in there just to make sure? Yeah, that's an important, carries with it. Put an asterisk. Thank you. Okay, so, Mr. Hooper, you heard your attorney state the terms of your plea agreement, and I see those same terms are written out in your written plea agreement that you've signed. Have you read this closely?
Yes, sir.
Have you gone over it in detail with your attorney? Make sure you had all your legal questions answered.
Yes, sir.
You understand you're waiving the right to go to a trial on this. This will be a final adjudication of all these cases, all these counts. You understand that?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement here today and
Yes, sir.
waiving these valuable rights?
Yes, sir.
Is there a factual basis for this?
We stipulate.
There is, Your Honor.
Very good. Okay, based upon that testimony, the court will accept your plea agreement, and the state is agreeing, and is count 1, 2, and 4 are dismissed. Count 3, traveling to meet a minor, there'll be an adjudication of guilt. The defendant will be sentenced to 3 years in state prison. You will get credit for all time served. That sentence will be followed by 7 years sex offender probation, no unsupervised contact with minors, no internet access, sex offender designation, standard fees and costs. You will have a waiver of supervision on the probation. The defendant will be required to submit a blood or swab specimens pursuant to the statute.
Your Honor? I'm sorry, the court just announced that there'd be a waiver of supervision on
Cost of
probation. I
cost.
believe it was cost of supervision.
Will waive the cost of
Thank
supervision.
you. I just want to be sure if
I
since
did
the
that
oral
yesterday,
pronouncement.
didn't I? Didn't you pick that up on it? You gotta watch me close.
That's correct, Judge.
Okay. Good.
Thank you, Judge.
That's why they're there, so they can keep me straight. Okay. Any questions?
No, sir.
You have 30 days to appeal this, even though you agreed to it, but you have 30 days to appeal the sentence if you wish. Thank you.
Thank you, Judge. That
That's all you
concludes
got.
my business this morning. Have a good day.
Thank you. Ms. Dudley?
Okay, let me print that score sheet so I can get
And I
that.
believe the first one I have is Todd Adams in 22 CF 1584.
Mr. Adams is present. He is here for sentencing. Your Honor, do you have a copy of the plea form? I do have a copy for you.
He's got a few done today, huh?
Thank you.
Your Honor, he entered the plea back on December 18th. He was set today for
Very good.
sentencing, and it's agreed upon sentence with the state.
Is that what I have to do on this?
Very good. Sir Bates, who's handling this for the state?
It's my
Okay,
case,
you
Your Honor.
pay attention. So, based upon the previously entered plea agreement, the defendant will be sentenced to, one, an adjudication of guilt, court costs in the amount of $1,040 and a $50,000 fine. As to the various counts, you will be sentenced to credit for time served, which means you'll be finished with counts 1, 3, and 6. As to counts 2 and 4, you'll receive 3 years. You're sentenced to 3 years Department of Corrections with credit for time served. And as to count 7, also 3 years Department of Corrections with a minimum mandatory, credit for time served. And as to count 8, also 3 years DOC, minimum mandatory, credit for time served. As to this last count 8, all the other counts, 1 through 7, are to run concurrent. They're running all together. That's a total of 3 years. But they're consecutive to count 8. There'll be a total incarcerative sentence of 6 years, Department of Corrections. Is that correct, Ms. Dudley?
That's correct, Your Honor.
State, correct
Yes, Your
rendition?
Honor, that's correct.
Okay. Even though you're being sentenced and this is based upon a plea agreement, sir, you do have 30 days to appeal this sentence, okay? Okay. Any questions?
No, sir.
Thank you.
The next case I have is Trevon Harris in 23 CF 1366. I do have a plea to a misdemeanor if I may approach.
You may.
This is
Thank you.
I did include the lesser included statute on there. And
So this is a
everybody has-
misdemeanor
Yes, sir, it
agreement?
is.
Okay. State?
That's correct, Judge.
Okay.
And he will be supervised by JCS.
I'm sorry?
He'll be supervised by JCS.
Very good. Court's executing the plea agreement.
Thank you, Judge.
Agreement of the parties.
And I believe that's all I have, Your Honor.
Thank you, Ms.
Thank
Dudley.
you.
You have a nice day.
You just-
Mr. Harper?
Judge, I do have one plea.
Okay.
I can call Travis Mingo. He is number 15 on the docket. He is present and approaching. He's before the court on 23 CF 943. Judge, at this time, he's going to withdraw his previously entered plea and enter a plea of no contest. Count 1 would be dismissed. Count 2 would be a plea to a lesser included offense of reckless driving, which is a misdemeanor. Count 3 would be as charged. Be adjudicated guilty, placed on 1 year probation on count 2, followed by 6 months probation as to count 3, which would be consecutive, for a total of 18 months of probation. Be assessed to court costs, show proof of a valid driver's license or eligibility. He's asking for probation with JCS. Standard conditions of probation, no drugs not prescribed, random UAs at least once a month. If I may approach, Judge.
You may.
That's the state's agreement, Your Honor.
Thank you. Okay, Mr. Wingo, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement that has those terms. Have you read this closely?
Yes, sir.
And have you gone over it in detail with your attorney? Make sure you had understood all the legal ins and outs of this agreement.
Yes, sir.
It does have some legal, ramifications. The main one is that you're waiving some valuable legal rights. The right to force the state to prove their case beyond every reasonable doubt. You're waiving that. This will be a final adjudication of your case. Is that what you want to do?
Yes, sir.
And you do believe that's in your best interest?
Yes, sir.
And nobody threatened or coerced you to get you to enter into this? This
No,
is
sir.
entered freely and voluntarily?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement, and the court will sentence you as follows. As to count one, it is being dismissed by the state. Count two is a plea to the lesser included offense of misdemeanor reckless driving. And count three is as charged. Are both of those adjudications of guilt, counsel? I wasn't
Yes,
clear
Judge.
on that.
There's no adjudication is the.
Okay, both are adjudication of guilt. 11 months, 29 probation as to count two, followed by 6 months probation as to count three. They'll be consecutive, so, for a total of 18 months probation. That's $300 in court costs, cost of defense, show proof of valid driver's license, no drugs that are not prescribed, random UAs, and UAs at least once a month. Okay, do you understand all that?
Yes, sir.
Any questions?
No, sir.
Okay. Even though you just got sentenced to this, you do have 30 days to appeal it, okay?
Yes, sir.
Do we have any
Look.
JCS codes? Yes. Thank you, sir. Thank you, Judge. It's not all we
Okay. Mr. Gates here? Well, you ran off. Okay.
Okay, so the other, I was thinking
We're going to
Mike
we'll
Gates.
probably take a break here in just a little bit, but let me just kind of see where we're going, because some of it is a little bit unclear coming into this. Where's Mr. Cobb? You ready?
Yes, sir, I am.
You're ready for trial, right?
Yes, sir. I
We're
am.
ramping up for trial.
Yes.
And you anticipate it being 2 days?
Well, picking the jury on day one, I guess, and then a day for a trial.
Okay, that's 1.5 days. Half day for jury.
That's fine.
I don't know, you agree?
No, state agrees, Your Honor. That's fine.
I'm just trying to kind of figure out where we're at, because we're gonna have to start looking at dates here in a little bit. So,
Do we not need
now,
Mr. Gaspin back?
Mr. Harper, you have several cases that.
Yes. I think that, the state and I have been in discussions, I think we might be moving one of those cases.
When you
But
say
the other two.
moving them, what do you mean
May,
moving?
may we approach on this?
Sure.
Thank you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
You got any pleas? You just called. You got trial going?
Now, just while we're waiting, because we're going to bring these out separately, but we'll wait.
Dan, just prep him as judge for what you just discussed. Judge, with respect to this, to the matters that we discussed at sidebar, with respect to Mr. Golden's case, which is number 13 on the docket before the court on 22 CF 256, 22 CF 288, and 22 CF 2095, the case that was currently scheduled for trial, case number 288. All of these cases we're going to ask to be moved to the 410 pretrial conference.
State.
We'll stipulate, Your Honor, we would ask that this be the last continuance.
The court, based on discussion with counsel, the court will continue this matter until 4:10, and we'll ask that the clerk's minutes reflect it'll be the last continuance.
Thank you, Judge.
And just by way of timing, I think you said earlier, and we're going to bring your clients out later. As to Dennis Foster, we're looking at a 1.5 day?
I think
I'm talking about including jury. I always look at jury selection a half day and then whatever else.
I think so, Judge. I think that we could, specifically, I'm asking for the 7th and 8th. The reason is because of witness availability. We could pick the jury on the 7th, and then after we pick the jury, we could sit together and figure out any problems with jury instructions, then go straight in.
I don't know that the court's going to be able to accommodate exact dates, but I don't know about the 7th and 8th may not work.
I understand, Your Honor. I have a witness who is a necessary witness who would only be available on the 7th and the 8th.
Well, how about doing it on the 6th and 7th?
We could make that work, Your Honor.
Okay. Anyway, we'll come back out and we're going to have our jury review. What are you looking at as far as with Jenkins?
Same, Judge. I think a day and a half.
Day and a half.
I would agree, Judge. Because of witness availability, I just wouldn't be able to try that case on the 7th and the 8th. That would have to be earlier in the week.
Sure, that's fine. Well, we wouldn't do it at the same time.
Sorry.
Thank you.
Can't do two trials at a time.
I
Either for you
understand.
or Mr. Harper. You're good, but not that good.
Thank you.
Okay. So good. Okay. Okay. Let me see something here. I think we'll take a short break. Where's Mr. Medina? Who's handling Beecham with Medina's?
That's
Are
mine,
you all
Your
still going?
Mr. Medina is currently talking to his client, Your Honor. I think after he talks to his client, we will know that for sure.
Okay, so that's still a plea or trial?
It is still, if it's not a plea, it's gonna be a trial.
Okay,
It'll have
so
to be.
I just want to know kind of where we're at, and we'll get the rest of,
But not PTC.
okay,
PT.
very good. Let's take a short break,
Okay, we'll go get the
and then
spreadsheet
we'll
that I
get it when they're all ready to go, let me know.
All rise,
Yeah,
please.
can't try the deed.
Court is in recess.
I'm gonna walk down. Do you have anything in the printer?